9th and 13th day of September 2024. Mama Lady, balance the scales of justice. Allow us to come on an even playing field before you to argue the merits or otherwise of the petition by allowing an order of conservatory order, as you have the powers, my lady, under the Constitution, to issue the reliefs that are sought. We humbly pray, my lady. Thank you. Unless, my lady, my other colleagues have anything I have not mentioned, if you allow them just a minute.
I think you've covered everything, to be fair.
My
Miss,
lady,
Miss Nanetia, Miss Lebo? Miss Lebo?
Yes, my lady.
Yes.
My lady, through Article 185 of the Constitution, it gives the first respondent the legislative authority. Article 209(3) also gives the county government the authority to impose property rates. My lady, Kajiado Rating Act also gives authority to the county to impose rates. My lady, as much as Article 185 gives the county assembly the legislative authority, however, it must conduct public participation through Article 196, Section 115 of the County Government Act, and Standing Order 121(3) of the County Assembly's Standing Orders. My lady, through that, the first respondent made an advertisement in the Daily Nation and in the Standard newspaper on 21st August 2023, advertising for the public participation. My lady, through that, the first respondent conducted public participation in each and every ward in Kajiado County. My lady, the first respondent has also provided a list, attendance list. My lady, the first respondent further advertised for the public participation through its Facebook, through the ward administrators, through WhatsApp groups, and also provided a link for the Kajiado Finance Bill. My lady, during the public participation, especially in Kajiado North, where it was conducted for Olkeri wards, both Ngai Mundurna and Ongata Rongai ward, in the social hall, Ongata Rongai, and Ngong wards. My lady, in the attendance list, we can also see that some of the petitioners were actually present during the public participation. My lady, council wants to mislead the court by stating that the Kajiado Finance Act is discriminatory. But if you look at the Finance Act in Part 2 of the 8th schedule, it talks about payments of rates for those holding more than 0.4 hectares of land. My lady, in our written submissions, in the case of Makumi and 4 others versus Speaker County Assembly of Kitui and others, the court pronounced itself by saying that a court dealing with an application for conservative orders must maintain the delicate balance of ensuring that it does not divulge into issues which are in the name of the main petition, my lady. My lady, it is the first respondent's position that while dealing with this application for conservatory orders, the court must maintain the delicate balance, ensuring that it does not divulge into issues which are in the realm of the main petition, my lady. My lady, the first respondent reiterates that through Article 2093, the county government has the authority to impose property rates and my lady, the first respondent also reiterates that public participation was conducted, and further, the public were given an opportunity to do a written memoranda my lady, the whole bill was subjected to public participation. And my lady, it is our position that issuance of conservative orders has a potential to paralyze the operation of the county.
Yes, proceed. Ms. Lebo?
Oh, sorry, my lady.
Yes.
My lady, it is our position that all the parties in this suit must have the ability and flexibility to prosecute their case or present their defense without prejudice. And that issuance of conservative orders
court should find in favor of the party that has demonstrated that there was public participation. And there is a lot of evidence, including reports, to show that public participation was done at the executive level and at county assembly level. My lady, there's an allegation of discrimination in the levying of land rates. An impression has been created that only small-scale landholders are supposed to pay rates. My lady, nothing is further from the truth. Lucky enough, the petitioner has provided the Kajiado Finance Act to the court. And I'll refer to the act itself. And the act runs from part 2, which deals with property rates, runs from page 119 all the way to, my lady, just a minute, all the way to page 131. And every category of landowner is covered. There are those who hold less than 0.05 hectares, they are covered. There are those who own huge tracts of land, and there's a formula that is provided there. And I can say without fear of contradiction that they pay more. My lady, a cursory look at part 2.
My lady, sorry for interjecting, my lady. Perhaps just council should direct us to that formula and where it pays so that we don't mislead the court. I'm following very keenly. Just tell us one so that we, even in rebuttal, it becomes easier.
My lady, I'll gladly do so. At page 122 of the Act, it is in your petition. Go to 122 of the Act. There is a place where it is written part 2, and it deals with malls, hotels, petrol stations, educational institutions, conservancies, and there is a formula there.
Just read the title. What is the title?
Land and property rates for adjudication section area. Kaputei Urban, Kitengela Urban, Kisaju East, Ngong Urban, or Lekasasi. It's there.
My lord, you're being misled, but I will respond to that.
Okay, proceed, Mr. Nyausi.
So much so that the emotions being whipped that this statute targets small-scale landholders is not true. It is not true at all. My lady, there has been also another allegation that provisions were sneaked into the Act. And I'm sorry to say this, that the petitioner relies on a flash disk of some deliberations in a political setting by politicians to try and discount the overwhelming evidence that we have provided to the court. My lady, that piece of evidence should be treated with the contempt it deserves. And that this court is a court of evidence that should make decisions based on the evidence provided by the court. And my lady, allegations of one member of county assembly cannot bind the entire county assembly. Then, my lady, the other issue that has been brought, or rather what you've been told is an issue of public importance, is that there is a debate as to whether rates should apply to freehold property. My lady, if there is anything
Alafu hiyo ni ya kama once in a month, si
that
kila
you'll
time.
find easy in
Siku zingine
determining
unaosha na hiyo dawa ya choo ya blue.
is that question.
Nimemute. Dawa ya blue
Because
ile ya
even
kama
Article
ina kama
209,
happy. Hiyo ni ya kutoa hizo
which
nini. Nakwambia
permits
sikosenge kuosha
county
choo ndio
governments
usipate
to
hizo
levy
stains
rates,
mbaya.
does not make that distinction.
Na urinzi kabisa hiyo inaweza choma mtu hata kwa tako akienda kukadia. Urinzi na maji mingi mtu anaweza chomeka na
Even
matako.
national legislation, which we have quoted extensively in our submissions, and these are old statutes enacted in the 50s, in the 60s, and in the 70s. Freehold property has always been subjected to land rates. There is nothing novel about that issue. In fact, my learned friend, in their petition, I think paragraph 31, have given the definition of freehold land, paragraph 30. And the definition is very clear that freehold land is subject to the interests of county governments. It's an appreciation that county governments have an interest in freehold land. So much so that, for me, even at this stage, with the material present before the court can confidently find that even freehold land is subject to rates, and that has been the practice. My lady, I'll go to my second limb of whether irreparable harm has been demonstrated, or rather whether there is prejudice. And my lady, you will note that this act was commenced on the 31st of October 2023. The act has been in place for 1 year now.
Auntie, hebu kwanza enda ukunywe maji.
The
Unaleta kufungua?
petitioners have known all along, since
Umekunywa
31st
maji?
of October 2023,
Hebu fanya haraka uende upande
that
nje
they are
kuna upepo.
supposed
Fungua
to pay
madirisha huko.
rates. So much so that there is nothing urgent to warrant the pressure which the petitioners are trying to exert on all parties. My lady, the first petitioner is an advocate of this court. I would assume.
My lady, I think counsel is getting the mark. The first petitioner is not an advocate. It's an
Is he
NGO.
as a petition? NGO. Sheria, mtaani, something. Mr. Nyausi?
It's okay, fine. I will rephrase my submissions. My lady, this piece of legislation was gazetted, and it is available to everyone in this country. From the 31st of October. The petitioners had the chance to challenge this legislation around that time. They didn't. Then came June, when they were supposed to pay rates. The petitioners did not challenge the statute. And then what triggered the petition? And it is in the petition. My learned friend has submitted that the second respondent went to sensitize members of the public on the provisions of the Finance Act. My lady, I have not seen anywhere where the petitioners have argued or rather provided evidence that the second respondent went to threaten the petitioners. It was a sensitization exercise. So much so that the petitioners have had adequate time to approach the court and try to argue their case. Ignorance of the law cannot be a defense. And in any event, inaction for 1 year cannot be used to justify, or rather, the inaction for 1 year is clear proof that they can wait for this court to determine the constitutionality of the provisions. My lady, I have also gone through the affidavits provided by the petitioners. My lady, no single piece of evidence of a rate demand has been provided. No evidence of threats of arrest have been provided. And what the petitioners have are mere apprehensions. Mere apprehensions that we will be arrested, our property will be so. All those are mere apprehensions. And I want to refer the court to the case of, it's at paragraph 22 of our submissions, the case of Martin Nyaga Wambora versus the Speaker of the County Assembly of Embu, where the court held that an alleged threatened violation that is remote and unlikely will not attract the court's attention. But a more precise authority will be the one we provided at paragraph 23 of our submissions, Progress Welfare Society of Malindi and 3 others versus the county government of Kilifi, where the court was very emphatic that therefore the burden is on the applicant to show there is danger which is imminent and evident, imminent and evident, true and actual, and fictitious danger, and which danger deserves immediate remedial attention or redress by the court. A remote danger will not do. In other words, the applicants must show the probability as opposed to mere possibility of the danger occurring. Now, what we have been treated to is an assortment of probabilities. Not even a demand for rates has been provided. And in any event, my lady, my learned friend has quoted provisions of the Kajiado Rating Act, which states that rates are collected as a civil debt. Again, no proceedings, no evidence of civil proceedings. And those proceedings, if any, will be instituted in a court of law. And if there are any violations, those issues will be addressed in those courts. So much so that there is no prejudice whatsoever that the applicants will face if the conservatory orders are not issued. My lady, there are people, there are members of Kajiado County who are paying rates and who have been paying rates since the 31st of October 2023. And rates are not new in Kajiado. There have been a Finance Act every year since 2016, providing for payment of rates. And in fact, when my lady will be retiring to look at the document, if you look at the first respondent's replying affidavit, Mr. Wamboi's clients have gotten a reduction in the rates payable from the Kajiado County Finance Act of 2020. So much so that, my lady, the conservatory orders being sought at this stage will occasion a lot of difficulties, especially in the operations of the second respondent. And that difficulty will be colossal and will affect the delivery of services for Kajiado County. My lady, no harm has been demonstrated, or there is no imminent danger. And payment of rates, it's a mandatory dispute. And we want to refer the court to the most recent authority, which came from the Supreme Court on the issue of conservatory orders. I mean, the issue of public interest.
Just point out the page and then I will read it.
Yes. I'm actually taking the quote to that exact paragraph 28 of my submissions. The Cabinet Secretary of Treasury and Planning and 4 others versus Okoiti Omtata. It's a decision of the Supreme Court which talks about public interest and it is very emphatic that public interest favors allowing such statutes to continue applying so that the respective governments can continue supporting their budgets. And the same reasoning was also made in paragraph 24 in the housing levy case, and this is, I think, by the Court of Appeal. Gikenyi and 41 others, what is the Cabinet Secretary for Lands, and 13 others. In fact, I want to read that quote and conclude my submissions. Then I move to the issue of empanelment. And the court stated that it is our finding, therefore, that in these instances, the petitioners have failed to either demonstrate that the impugned provisions of the Act pose a danger to life, limb, or threaten the Bill of Rights to warrant the issue of conservatory orders. It has further not been demonstrated that the collection of housing levy is irreversible. Taking into consideration the above case law and the divergent positions of the party on the nugatory aspects, we are not persuaded that the petitioner will be rendered nugatory if the conservatory orders are not granted. Again, rates are monetary payments and they can be recovered just like the housing levy. And I also want to state that the Housing Act, which was subject of challenge in that act, also contained provisions that created criminal offenses. And the court did not see the need to stop the application of the act. With those few remarks, I urge the court to dismiss the application for conservatory orders, allow the main petition to proceed. We are willing to fast track the main petition so that each party can get its pound of flesh. Now, on the issue of the expanded bench, I don't know, my lady, whether I should make brief submissions.
Did you didn't make it there?
No, because all the directions have been on the application for conservatory orders.
You can just use 1 minute to say whether you support or not.
Well, I do not support the empanelment because the issues that are on trial in this petition are issues that the courts have dealt with, public participation, and the other issues of discrimination. There is enough jurisprudence from the Supreme Court to guide this honorable court on determining that issue. So it's my view, it's my considered view that such an application or such empanelment will delay the determination of this petition. So I urge the court to decline the invitation to refer this petition to the Chief Justice and give us directions for the hearing of the main petition. That's all.
Mr. Wambui, I hope you will be gracious to just respond on the issue of the formula because I'm running out of time.
Thank you, my lady. My lady, first.
Just that issue, please.
Yes. My lady, in an attempt to mislead you that we have not persuaded you on the question of discrimination, my lady, you have been misdirected to parts of the 8th schedule of the Act. My lady, I invite you to look at the first part 2, the one that we have highlighted in our pleadings, has not been brought to question. I suppose because of the inelegance of drafting of this act, there is a replication of another part 2, which, my lady, makes a reference to land and property rates for adjudicated sections areas. We have no problem for these adjudicated section areas. In any event, we've not even raised that concern before court. So it appears that the respondents are replying to what we have not even invited the court to consider. I invite you to look at the part 2 of the land and property rates that we have highlighted. We've even given the figures and we have shown land rates is imposed on small scale landowners. My lady, on the second question, public participation. My lady, as a matter of fact, the reason why the court should consider granting the orders that we seek is actually on the evidence presented before this court. To lie to you that there was a public participation that was conducted. My lady, I turn to paragraph 14 of the affidavit, replying affidavit by the second respondent, which was clear that public participation only happened in 2, if at all it happened in 2 constituencies. My lady, the last time we appeared before you, you gave them an opportunity of filing a further affidavit. Their further affidavit, my lady, I invite you to look at it. They have shown, they have presented to us reports that there was public participation on the 6th day of June, 2023. Those reports are not signed. From the year 2023, I mean, Council has insisted from the year 2023. So to date, 2024, just to show, my lady, that this could actually be a creation from the part of the second respondent, is that they have not signed the report that they has presented before us. My lady, to add to that, the second respondent has provided images of attendees, which, my lady, I cannot read. I concede on my part, I cannot even read the attendees. And I am persuaded, my lady, beyond peradventure, that even from where my lady sits, cannot read who attended, which is deliberate. There was no public participation conducted. My lady, still on that line, on the images, they have presented images of persons whom they have not even been generous enough to share a certificate of electronic evidence so that we can know what is the source of these images. Who are these? When were these images taken?
My ladies, I'm tempted to object.
My lady, I am on my feet. It is a question. There is no electronic evidence. It is there. I mean, my lady, we cannot recreate the file. My lady, secondly, you also gave an opportunity to the first and fourth respondent to also share a further affidavit, which I invite the court, my lady. It is dated yesterday, the 7th day of October, but served on us today morning. My lady, for some reason, they thought we will not read. But my lady, I have taken my time, I have read. And one important thing I invite the court to check, my lady, the annexure presented by counsel for the by the first and fourth respondent, KCA1, is a screenshot, my lady, of our subgroup known as Kajiado Opinion Leaders. Demonstrate that there was public participation that was called, now not on the 6th day of June, my lady. They now tell us public participation happened on the 13th day of September 2023. It is there, my lady.
My lady, you see the danger of...
My lady, I am speaking to documents. Counsel should just hold his horses.
Mr. Amboi.
Yes.
There is a clear distinction between the first respondent and the second respondent. And there are two levels of public participation. There is the pre-legislation public participation, and there is public participation during legislation.
I'm sure I'll go through it. Mr. Amboi, I
see,
think you have exhausted.
That is the danger of reopening things that we are unable to respond to.
Mr. Amboi.
Yes.
I'd only asked you to talk about the formula, about discrimination. Please, let's just wind up, because other people are waiting for me in court.
My lady, lastly, on the questions of probabilities, because it was deponed that, because probabilities now we have not proved that we will suffer prejudice. Yes. My lady, in other words, counsel is asking you to surrender us to the mercies of our oppressor, the respondents, so that, my lady, they can decide when to arrest us, when to charge us, when to commence civil proceedings. My lady, as it is right now, the impugned laws give them the power of imposing criminal sanctions on us while this matter is pending before you. My lady, the authority that has been cited to you by counsel on the question of CDF Act is clearly distinguishable, and especially with this matter and these circumstances, of no use to this honorable court. Because, my lady, the challenge on the CDF Act did not impose any criminal sanctions. And therefore, that court while deciding that question was in order to restrain itself from issuing conservatory orders at the interlocutory stage. And my lady, we know what became of that CDF Act. It was declared unconstitutional. And so is the other NGCDF Acts. So, my lady, if that is the history that council want us to rely on, I invite the court to decline that invitation. My lady, I shall not speak more. I shall only be urging you to focus on areas of the law that we have challenged. Let us not be dragged by the respondents to other areas that we have not called to question. The invitation is for us to use a guided missile approach, my lady, in the determination of the issues presented before court. I urge you to allow our application. My lady, a question as to the empanelment of the court. My lady, was one that was up for determination. In fact, counsel representing the first and fourth respondent has put in their submissions. So if Mr. Nyaosi for the second respondent has been negligent on duty, my lady, we cannot all suffer.
My lady, I thought I have made my submissions on that issue.
He has replied. Okay, so let me give you a date for the ruling.
Fair enough, my lady. Thank you.
So 20th of November.
We are most obliged.
Yes, so in the meantime, we still maintain that no one will be arrested.
That's okay.
Most
I'm happy
obliged,
with that.
20th November. Thank you, my lady.
Okay, thank you. Enjoy the rest of the day.
Thank you, my lady. Respondents.
My lady, if I may.
Miss Songila, I'm heading to court now. What is it?
My lady, if I may, there was a matter coming up for mention before you today. Joseph Karanja and 9 others versus Kigutha Development and another.
That's a Milimani matter.
Yes, my lady.